Court has reserved judgment in a suit filed by 19 state governments against the federal government, challenging the constitutionality of the laws establishing the Economic and Financial Crimes Commission and 2 others to a date to be communicated to the parties. The plaintiffs in the suit argued that the Supreme Court in Dr. Joseph Wobike versus Federal Republic of Nigeria had held that it was a United Nations Convention Against Corruption that reduced into the EFCC Establishment Act, and that in enacting this law in 2004, the provision of Section 12 of the 1999 Constitution as amended was not followed. The argument was that in bringing a convention into the Nigerian law, the provision of Section 12 must be complied with, adding that the provision of the Constitution necessitated the majority of the state houses of assembly agreeing to bring the convention in before passing the EFCC Act and others, which was allegedly never done. The argument of the states in their present suit, which they had reportedly been collaborated by the Supreme Court in the previous case mentioned, is that the law as enacted could not be applied to states that never approved of it, in accordance with the provisions of the Nigerian Constitution, adding that any institution so formed on the basis of reducing a UN convention to law should be regarded as an illegal institution. The Attorney General of the Federation, Lateef Wabemi, SAN, who was present in court as the defendant, had craved the court's indulgence to take the process they filed on Tuesday morning, while Justice Owani Abba Aji thereby granted leave to the defendants to use the reply on point of law filed on Tuesday. Ndamzi, what do you make of the story?
Yes, thank you. You see, EFCC Establishment Act of 2003 was an offshoot of a convention. Okay, then, you know, President Obasanjo then was moving about trying to get loan review and cancellation from the Paris and London clubs. So the Paris and London clubs then gave a directive that Nigeria is not a member of the Financial Action Task Force, FATF. Okay? That since Nigeria wasn't a member of FATF, that it will have far-reaching consequences on the review of the loan. So that necessitated Obasanjo then to fast-track the EFCC Establishment Bill, which was passed within 2 days. In fact, from the history of legislations in Nigeria, since the creation of this country to date, the EFCC Establishment Act is the fastest bill so far passed in the history of Nigeria. 2 days. It was submitted today and passed the next day. So in doing so, you will see there will be lots of lacunas, there will be mistakes, and the intendment of the act itself. The National Assembly, in making that bill, overstepped its bounds. Okay? Let us go back to the constitutionality or otherwise of the EFCC. I am one of the lawyers in Nigeria who strongly believe that EFCC is unconstitutional. The EFCC, as far as Nigeria is today, is unconstitutional. Why do I say this? Section 12, subsection 2 of the 1999 Constitution as amended says that any convention that Nigeria and any foreign nation or body is to ratify here in Nigeria must be made lawful by the National Assembly. So that is to say the National Assembly will pass it into law before it can stand as law in Nigeria. So if you look at Joseph Nwabike against Federal Republic of Nigeria, the EFCC was very clear in interpreting Section 12, subsection 2 of the Constitution. And the Supreme Court re-echoed the position of Section 12, sub 2, in that Nwabike and the Federal Republic of Nigeria, where the Supreme Court said that foreign enactments and all that has to be domesticated within the Nigerian laws before it will stand. Then going by the purport of Section 15, subsection 5 of the 1999 Constitution as amended is very clear. The Constitution there says that states shall do what? Fight corruption and abuse of power.
Not federal, but states.
Not federal, states. So now, in enacting such an act in Nigeria, knowing that it was a UN convention that is to be domesticated here in Nigeria, you must carry the states along. The National Assembly cannot pass that act
without the ratification of houses of assembly.
Without the ratification of the states in Nigeria. Don't also forget, if we are looking at the justiciability of Section 15, why make a law if fight against corruption is so important to Nigeria? Why make that section non-justiciable? That is the problem. And in my view as a lawyer, I think that is the reason why the EFCC, the ICPC, the NFIU, they have not done well in their convictions in court. Let us look at the contest, corruption itself as a contest in Nigeria, the huge fraud cases in Nigeria. What is the result? In my opinion, EFCC have underperformed. They have achieved little or nothing. Look at the general concept as to the amount of money stolen in Nigeria. How many have EFCC recovered? They told us that 2022 till now, they recovered about $120 million. That is just a meager amount compared to what have been stolen or what have been fraudulently taken away from the country. So, EFCC, in my view as a lawyer, it's an unconstitutional organization.
All right.
So, this is a time, going by Dr. Lisa Bakoba's letter to the National Assembly, and also the decision in Joseph Nwabike against Federal Republic of Nigeria, I think this is a time to constitutionalize EFCC.
Okay.
Otherwise, as it stands till today, till whenever the Supreme Court gives that judgment, EFCC, in my opinion, is an unconstitutional organization, is an illegal organization, and it has performed little or nothing.
All right.